appeal in the matter of India and Secretary of State for the Home Department.
Yes, Ms. Malik, thank you both very much for all of you, for arranging to sit at 10 o'clock. We noted that the time estimate was 3 hours, so it seemed to us to be very sensible that we simply list it so that the matter is completed in the morning.
Very grateful.
If in fact you need 3 hours, which I think is pretty unlikely. We've all, if I can just tell you, we've all had an opportunity of reading the papers, so we've read the judgments, we've read your respective skeleton arguments, and we've had an opportunity of dipping into the relevant authorities.
Very grateful. So, Lady Lords, I appear for the appellant this morning with Mr.
Yes.
Raza. Moylan friend Mr. Chapman appears for the Secretary of State. The issue in this appeal is whether Judge Cockrell at the first-year tribunal had erred in law in adopting the finding made by Judge Hodgkinson that the appellant did not cheat in her TOIEC test. And I shall seek to persuade my lady and my lords that the answer to this issue, contrary to the conclusion reached by Judge Henson at the upper tribunal, is in the negative. The law is now authoritatively set out in the judgment of my Lord Justice William Davis in the case of Sultana. So what I propose to do this morning, at the risk of testing my Lord's patience, is to make 3 short points that arise from Sultana before taking the court to it. I will then take the court to the judgment of this court in Asan that would assist the court with the context of this litigation. And these are the 2 authorities that I propose to take the court to. I will then make some very brief submissions on the facts of this case and the application of the principles. And at the end of my submissions, I will seek to assist the court with 4 particular points that my learned friend has made in his skeleton argument.
Yes, thank
So
you.
Sultana first.
Yes.
Three short points that arise from Sultana in my submission. First, the principle of res judicata and estoppel do not apply in immigration cases, but the principles in the classic case of Devasalin do apply, and they apply to the Secretary of State in the same way as they apply to the appellants. Second, the test in Devasalin essentially mirrors the test in Laden Marshall. If in cases of this nature, the Secretary of State fails to produce all the evidence at the tribunal that ought to have been or could have been produced with reasonable diligence, she cannot then seek to reopen the tribunal's findings in the subsequent proceedings. And third, where an appellant seeks to argue that the Secretary of State is not entitled to depart from the earlier findings made by the tribunal, that appellant must make that argument either in a fresh appeal or by way of judicial review. If an appellant does not make that argument before the first-year tribunal, that appellant cannot then complain that the tribunal erred in law in allowing relitigation of the issue. So Sultana is behind tab 10 of the authorities bundle. The court, I'm sure, is familiar with the background. Mrs. Sultana was accused of relying on false bank documents. There was an appeal to the first-year tribunal. And this is the first point of distinction on facts. Shortly before the appeal hearing, Mrs. Sultana submitted 2 letters from the bank in question, showing that the documents originally provided were genuine. On the basis of those documents, the judge allows Mrs. Sultana's appeal, concludes that she was innocent. The Secretary of State then conducts an investigation, and it emerges that the documents that Mrs. Sultana had provided to the judge were also false. And the Secretary of State then refuses the application. So that was a case where not only false representations were made to the Secretary of State, the judgment of the first-year tribunal was obtained by fraud. There was then a fresh appeal to the first-year tribunal, and this is the second point of distinction on facts. In that appeal, Mrs. Sultana did not argue that the Secretary of State was not entitled to depart from the first judicial decision. She adduced further evidence, and there was then a re-hearing of the issue. The second judge, applied the principles in Devasali, considers all the evidence and concludes that all the documents that have been provided were false and dismisses the appeal for that reason. There was then an appeal to the upper tribunal where the judge agrees with the second judge at the first-year tribunal, dismisses the appeal, and the matter then reached this court. The discussion is set out at paragraphs 42 to paragraphs 53. If you look at paragraph 42, you'll see the first and primary reason given by my lord for dismissing that appeal. You'll see that at paragraph 42, my lord refers to an unchallenged finding made by the upper tribunal that the Secretary of State had no opportunity to verify the two letters that were submitted by Mrs. Sultana prior to the appeal hearing. And my lord concludes at paragraph 43, assuming that Laird and Marshall applies, that test was met because the Secretary of State could not have, with reasonable diligence, provided evidence that those documents were false because she had no opportunity to verify those documents, and my lord concluded that the appeal fails for that reason alone. But my lord then, in any event, dealt with the arguments as to the law. If you look at paragraph 45 of the judgment, my lord refers to BK Afghanistan, and the conclusions are set out at paragraph 46. This is what Lady Justice Rose, as she then was, said about the case of Devaslin. You have the 8 principles, and for the purpose of this appeal, I emphasize on principle 1 and principle 7. Principle 1 is that the first decision should always be the starting point. And principle 7 on the next page, you will see refers to some very good reason why the appellant's failure to adduce relevant evidence before the first adjudicator should not be, as it were, held against him. That applies to the Secretary of State as well. If you then look at paragraph 47 and see what my lord said in the last 3 sentences, there is an express endorsement that the principle applies with equal force to the Secretary of State. And then my lord said that where in relation to a particular issue, and again I especially emphasize the word particular issue, the Secretary of State seeks to rely on facts not materially different from those on which he relied in the first appeal, the first judge hearing should regard the issue as having been settled in the decision reached at the first appeal. And then at paragraph 49, Lady and Lords will see a reference to the case of Mubu, that is the lead authority at the tribunal level on the subject. And you'll see that it refers to the earlier case law, including Jabba and A. Somalia. And my lord then adopted what was said by Lady Justice Rose in BK Afghanistan. If you go to the next page, this is page 218 of the bundle, and consider line 5. A tribunal must be alive to the unfairness to the opposing party of having to re-litigate a point on which they have previously succeeded, particularly where the point was not then challenged on appeal.
How does that apply to this case?
Because one of, well, the later part, of course, does not apply.
Quite.
But the first part is relevant.
Well, the basis
But
for the
he's-
guidance is not estoppel or res judicata, but fairness.
Yes.
So it's an overarching assessment of fairness
Yes.
in the interests of justice.
Yes.
And that will depend on the circumstances of the individual case.
Yes.
If relitigating a point is obviously a significant factor.
Yes.
That is not present in this case. There's no relitigation between the parties of a point that was decided between them.
Well, I shall seek to persuade the court that there is relitigation on the conclusion that is reached by the upper tribunal. So the first
But
judge...
in relation to a different party.
Yes, but that makes no difference because it is common ground based on a judgment of this court that Devasalin principles apply also to a case where to a party that wasn't a party to the earlier appeal.
The principles apply, but the application of the principles might lead to a different outcome depending on whether or not it is relitigation between the same parties or litigation involving a different party but raising the same factual issue. Do you accept that?
I
That
accept
it's
that.
a relevant
I accept
factor?
that.
Yeah.
I accept that. Good.
Thank you.
If you then look at what my lord said afterwards, and you'll see that my lord there addressed the meaning of some very good reason in Devasalin. And the conclusion is set out at paragraph 51. Towards the end of the page, my lord concludes that the test in Devasalin, the reference to some very good reason, essentially mirrors the Laird and Marshall test. And you will see that the submission that Mrs. Sultana made on the law was accepted, and the conclusion is that the Secretary of State, when making a decision consequent upon a decision of the first-year tribunal, will be subjected to the principle analogous to those found in Laird and Marshall. And then finally, if you look at paragraph 52, you'll see that my lord gave another reason for dismissing the appeal on facts. You'll see that the reason is that the point in question was not made to the first-year tribunal. These are the last three sentences at paragraph 52. And the point essentially is that if a point is not made to the judge, then the party cannot say that the judge erred in law in not engaging with the point. So that is Sultana.
Thank you.
As I indicated, I was posing to take the court to Austin, but given the question that my lord has raised, may I just show one further authority to the court that may assist. That is behind tab 8 of the bundle, the judgment of this court in Ocampo. Miller and Friend has referred to this authority in the judgment. You'll see, and again, it's common ground. Miller and Friend says that in his skeleton, that this case was somewhat similar to the present case in the sense that the party to the second appeal was not the same as the party to the first appeal. Miller and Friend says that it is materially identical in the context. So the findings were made. So there was an appeal by the appellant's daughter. The daughter was successful in the asylum appeal and was granted refugee status. The second judge, who heard the appeal of the father, the appellant in this appeal, arrived at a different conclusion. And there was a discussion as to whether Devasalin actually applies and to the extent to which it applies. And the conclusion is at paragraph 25.
Thank you.
And it's not different from what my lord was contemplating, but you'll see from paragraph 25 that the court arrived at a clear conclusion that the principle applies to cases of this nature, where the parties involved are not the same, but there is a material overlap of the evidence.
And there's later discussion of what that means.
Yes, absolutely.
And it's, yeah. But then it goes on, you're going to come to clearly the guidance may need adaptation.
Yes, absolutely.
But that is got the overarching principle is the court. It's the last sentence in immigration matters, as in other areas of public law policy interests of firmness, consistency, and due process may have to be tempered with considerations of fairness in particular circumstances. And isn't that what Lady Justice Rose focuses on? Is fairness?
I do not
Right.
disagree with that.
Sorry.
At all.
Yeah, thank you.
That is fairness, and the submission that I will make is that if the matter goes back to the first year tribunal, contrary to the conclusion reached by the upper tribunal, it would be unfair to Mrs. Patel, and I shall make very brief submissions on that.
Thank you.
There's one final authority that
Yes.
will assist you on the context. It is the judgment of this court in Austin. You have
Yes.
that behind tab 1 of the bundle. My Lord Justice William Davis, of course, has experience of dealing with TOIEC fraud cases. But this judgment would provide the necessary context of this particular litigation. If you look at the first paragraph of the judgment, you'll see a short summary of the TOIEC litigation. The court, I suspect, knows this already. There was a BBC Panorama documentary in February 2014. The Secretary of State took the view that over 40,000 applicants cheated in their English language tests. The Secretary of State made decisions refusing leave, issuing removal decisions based on the evidence that she had. It later emerged that the evidence wasn't as good as the Secretary of State thought it was, and that gave rise to a series of cases. If you look at page 11 of the bundle, you'll see a heading, the TOIEC litigation to date. And I do invite Milady and Lords to consider paragraphs 22 to 23.
Do you want us to read that to
No,
ourselves?
not now, obviously.
We can do if you. I mean, we can quickly read those two paragraphs.
Well, yes. I mean, these are good 10 paragraphs. But if it assists, I can summarize what the position
Very
is.
well.
And perhaps just highlight the paragraphs that are of particular relevance. So you'll see from paragraph 23. At paragraph 23, Lord Justice Underhill refers to the evidence that the Secretary of State produces in cases of this nature, the lookup tool, the generic evidence, witness statements from the witnesses.
Which is all the evidence we've got in the supplementary bundle.
Yes, absolutely. And then paragraph 31, there is reference to some further cases, including the case of Abbas. That was the decision of my Lord Justice William Davis in the High Court. And you'll see what is said at page 14, just above paragraph 32. But the upshot really is at paragraph 33 that despite all this evidence, all this evidence is not determinative. So even where the Secretary of State proves that the test was taken at an established fraud factory, this is the particular phrase that is
Yes.
being used in the case law, and even where the recording of the test does not match the voice of the appellant, that would not be determinative. There would need to be an assessment of the particular facts and the evidence that an appellant provides. So it's not, the reason that I'm taking the court to this judgment is to emphasize that it's not the case that by producing the evidence that the Secretary of State has produced, that evidence does not establish on its own that the appellant was guilty of fraud. So this is us, and if I may now make some very brief submissions on the facts and the decisions taken below. The first decision of Judge Hodgkinson, is at page 103 of the bundle. Now, this was the appeal of the appellant's husband. Now, the appellant's husband was the dependent of the appellant. And you will see the uncontroversial relevant history from paragraphs 2 to 12. And if you look at paragraph 6, so the Secretary of State had refused the husband's application on the basis that his wife had cheated in the TOIEC test. Because the husband was the dependent of the wife, if wife had cheated, then the wife had no right to reside in the UK, the husband consequently had no right. They issued, the Secretary of State issued removal decisions, and ultimately there was an appealable decision that was issued. If you look at page 105 of the bundle, paragraph 15, you'll see a summary of the Secretary of State's conclusion. And if you look at paragraph 15, subparagraph 3, the Secretary of State's case was that the appellant's, that the husband's appeal should fail because the wife was guilty of cheating. She used a proxy, and the appellant, being a dependent of the wife, is liable to removal from the UK. Now, page 106, the appellant and his wife gave evidence. They both had adduced witness statements. And you will see that, unsurprisingly, that the focus was on the wife's evidence, because the allegation was against the wife. And if you look at paragraph 16, you'll see that paragraph 16 onwards, the judge summarizes the wife's evidence, that she never used deception, she did not use a proxy. And then she explained her background, how and when she took the test, and why there was no need for her to cheat. This is paragraph 22. Quite detailed evidence that the wife had provided. And you will then see the evidence that was given at the hearing at paragraph 25, the reference to that evidence. Now, paragraph 29, the Secretary of State applied for an adjournment. And you'll see that the reason for the adjournment application was to enable the Secretary of State to decide the wife's application so that there can be a sort of single appeal. And then see paragraph 30 in particular, and that may assist my Lord in relation to the question that my Lord has. It was the Secretary of State who said to the judge that your decision is going to have an important impact on the wife's case. And that is the reason why it is appropriate to adjourn, so that the two cases could be heard together. No good reason was provided as to why the usual ETS bundle had not been filed. And of course, you will consider this in the context that the appellant was accused of deception in 2015. So she had spent 4 years in this litigation trying to establish that she was innocent, applications after applications, claims after claims, and 4 years after, when there is a fact-finding hearing on this issue, the Secretary of State adduces no evidence. The judge takes the view at paragraph 31 that there is no good reason as to why the bundle wasn't provided, because the Secretary of State knew about this allegation that was made way back in 2015. It was repeated in the decision under appeal, and the judge makes a case management decision to proceed with the hearing. Now, the judge could have allowed the appeal simply on the basis, it could have resolved this issue of deception in the appellant's favor, simply on the basis that the Secretary of State had not adduced any evidence. But that's not what the judge did. If you look at paragraph 34, the judge carefully scrutinizes the oral evidence, the written and oral evidence that Mrs. Patel had given. And this is the second sentence of paragraph 34. Mr. Williams, who appeared for the Secretary of State, elected not to cross-examine Mrs. Patel. Opportunity to the Secretary of State to challenge Mrs. Patel's evidence, the evidence that I've shown you, which is set out in paragraph 17 to 24. A decision is made not to cross-examine her. No evidence is produced, and the outcome is unsurprising. If you look at paragraph 35, the judge refers to SM and Qadir. You have seen references to the case law in Asan. The burden of proof is on the Secretary of State. There is an initial burden of proof. Then the appellant is required to provide an explanation. The question for the judge is whether explanation should be admitted. Paragraph 36, first sentence, the respondent has produced no evidence. That's the first reason the judge gave. But then the judge explains that, well, forget about that. Mrs. Patel had adduced evidence. And that evidence is unchallenged. And the judge accepts that evidence. As in my submission, he was entitled to do so. And the conclusion, the overall conclusion is at paragraph 37, that the removal decisions taken in 2015 were on a mistaken basis. The Secretary of State has not proved deception, and Mrs. Patel was innocent.
So where does it... Just take me to where, I'm sorry, where it says that she's innocent as opposed to the fact that it hadn't been established.
I apologize, I was seeking to rephrase, but
I think they're very different.
Well, if the Secretary of State wasn't able to prove that she was dishonest, and the judge accepts the innocent explanation.
The finding of the judge was, I conclude that the alleged deception has not been established.
Well, that is the finding, yes. And the conclusion is that those removal decisions should not have been issued.
But that didn't impact on the overall decision, which was that the Article 8 appeal failed.
Yes, that is correct, because it was the husband's appeal. The wife had pending application at that time. The judge takes the view that the appeal should fail. The Article 8 appeal should fail, unsurprisingly, because husband had no freestanding basis to reside in the UK. But that was the finding on the issue, the primary issue that was before the judge. The Secretary of State then issues a decision in the wife's appeal, the appellant's appeal. That decision is at page 91. And Milady Milords will recall that, as I submitted, it was the Secretary of State who told the judge that his decision in the husband's appeal is going to have an important impact on the wife's appeal. But in making that decision, the Secretary of State simply ignores what the judge had said about that issue in the husband's appeal. The Secretary of State again asserts that there was fraud and refuses wife's application on TOIEC basis. There is then a second appeal, and the grounds of the second appeal are at paragraph 82, page 82. And may I respectfully take the court to page 84 of the bundle, where you have the first ground of appeal, and this is to meet one of the points that Lord Justice William Davis made in Sultana. So unlike Sultana, in this case, see paragraph 6 of the grounds. The main point made by Mrs. Patel was that the Secretary of State is not entitled to go beyond the positive findings made by the judge in the husband's appeal, and notes that the appellant had given evidence which was not contested. The appellant then refers to Mubu and another decision of the upper tribunal that is relevant. So that's the primary point made by the appellant. The alternative point made at paragraphs 10 to 12 is that, well, even if that point is not good, the appellant is innocent. She has provided an innocent explanation. The matter then goes before Judge Cockrell in the first year tribunal. This is page 61. So the Secretary of State is represented by counsel, an experienced counsel, previous presenting officer. And you will see what happened at the hearing at page 63. If you look at paragraph 18, you will see the central point that was made by the appellant, namely that the first judge had made a decision and this judge should adopt those findings. The judge then refers at paragraph 20 to the findings that you have already seen. You'll see that I took the judge to Mugu and BK Afghanistan and Asan, the three authorities that you have seen, paragraphs 21, 22, 23, and 24. Paragraph 25 is what the Secretary of State submitted. You'll see that she relied on the refusal letter. The refusal letter said nothing about the first judge's decision. And then then the point is made that, well, the appeal was dismissed and reliance was made on Professor French's report. That was the argument that was made by the Secretary of State. There wasn't any suggestion that the first judge made the wrong decision or there was any unfairness to the Secretary of State. You'll see the response at paragraph 26 that the report in question was available, had been available since April 2016. No reasons have been put forward as to why that wasn't adduced by the Secretary of State at the earlier appeal. You then have a heading findings and reasons at page 65. Burden of proof is on the Secretary of State. A summary of the submissions is repeated at paragraph 28. And then you will see the only point that was made on behalf of the respondent at paragraph 29. The Secretary of State did not say that, well, fairness requires a departure from the earlier findings. There's some procedural hiccup previously, or anything of that sort. And the judge is expected to deal with the points that are made by the parties. The judge cannot be said to have erred in law in not engaging expressly with the point that a party hasn't made. That is the point that my Lord Justice William Davis made. And you will then see paragraph 29, last sentence, that no proper explanation has been provided as to why it was not forthcoming before the first judge. Paragraph 30, in my respective submission, shows that the judge directed himself properly. There is an express reference to Devaslin. He is not saying that, well, the first decision is binding, this res judicata, or this estoppel. He says categorically that the first decision is a proper starting point. So he took the first decision not as determinative, but as a starting point. And then said, well, the Secretary of State has adduced nothing which would enable a different conclusion to be reached. And he then explains the reasons for that at paragraph 31. He refers back to Mubu and BK Afghanistan. And after taking the first judge's decision as a starting point, concludes that that decision should be maintained. And then explains further at paragraph 32 that the Secretary of State provided no explanation at all as to why the relevant evidence was not made available to the first judge. There's no question of that. There wasn't even a submission that there was a good reason for not providing the evidence to the Secretary of State. Surely the Secretary of State, with reasonable diligence, could have provided the evidence that you now have before the court at the first hearing, provided no explanation why she failed to do so. And then the judge concludes in my submission, unsurprisingly, at paragraph 34, that he would adopt the findings made by the first judge and allow the appeal. The decision to allow the appeal is unsurprising because of the jurisprudence on the subject. This court has said that where a person is accused of deception in a TOIEC test, and there is then a human rights claim, and in the appeal it is established that the person wasn't guilty of fraud, then the Secretary of State must put the appellant in the same position where he or she would have been if the wrong allegation hadn't been taken, and that means that that person would be granted some form of leave to remain, and that essentially means that Article 8 appeal should be allowed. So the Article 8 appeals allowed. The Article 8 appeal was allowed. The Secretary of State then.
Just before you go on, why didn't that apply to Mr. Patel?
Well, because Mr. Patel was a dependent of the appellant.
Yes, well, I follow that, but the Judge Hodgkinson, I don't know whether it's a man or a woman, said the TOEIC test was not
Absolutely.
a deception, or at least it's not been established that it was.
Absolutely.
So why did Mr. Patel not go back to square one?
But he should have been. Of course, I'm not going to make a submission that Judge Hodgkinson's decision to dismiss the Article 8 appeal was wrong, because I'm way out of time to do that.
Well, I was going to say, but on the face of it,
absolutely,
there could have been an appeal against Judge Hodgkinson's decision to go on and consider Article 8 on its merits.
Absolutely, and it seems that Judge Hodgkinson's attention was not drawn to the case law that I've just referred you to.
Okay.
But the husband's appeal should have been allowed, but it wasn't allowed.
No, I follow. But that's why Judge Cockrell,
Simply allowed.
he or she, is it a he or a she?
He,
right. So Judge Cockrell took what you would call the conventional route.
Yes.
Right.
Without opposition from the Secretary of State.
No. Well, I understand that. And Judge Cockrell, he refers to having a bundle with lots of annexes. Was that the full ETS bundle, the statements from people like Millington and Collins and Sewell?
It was, yes.
If it helps, my lord, the supplemental bundle, the material in the supplemental bundle was all before the judge,
right.
But there was some other material as well.
Yes, quite, which doesn't. Yeah. I just wondered why Mr. Nath, whoever he is, simply kept going on about Professor French's report.
Yes, and my lord knows from his judgment in Abbas that report is far from being determinative.
Well, it's part of the picture. I just wondered why Mr. Nath thought that was so important.
Yes, I mean that. Yeah. But he focused simply on that report, and the judge is not expected to say anything apart from what is submitted by counsel. But the submissions that I've made would apply not only to Professor French's report, but also to all other evidence that you have provided. Of course, there's no explanation at all.
Well, self-evidently, it predated.
Yes.
The first appeal.
Yes.
Because the decision letter in Mr. Patel's case was predicated on all this material.
Absolutely.
Yeah. All right.
Absolutely. So, and then there is an appeal to the upper tribunal. So you have, and the grounds of the Secretary of State's appeal are at page 58. So the ground one is material error of law, and if you look at the second last paragraph, this is the pleaded ground that, well, the judge erred in not fully considering any evidence from the appellant, and not allowing the respondent to prove their case.
Where are you reading from?
This is page 58.
Yes.
This is the Secretary of State's appeal.
Yes.
Second last paragraph.
Which starts?
It would, I would respectfully submit.
Okay.
And the point is that, well, the respondent wasn't given a chance to prove the case. The respondent had every chance to prove the case. He had that opportunity She had that opportunity before the first judge. She had that opportunity before the second judge. Before the second judge, the Secretary of State could have given a reason as to why the evidence wasn't produced earlier to enable the second judge to depart from the earlier findings. That wasn't done. And then findings on facts are made that do not really engage with the point that the judge was making. So the real point that was made by the Secretary of State is in this paragraph that, well, you haven't considered the appellant's evidence in full, and the respondent wasn't given an opportunity to prove. No point about fairness or anything. It wasn't said that, well, on Mubu or BK Afghanistan or Devaslin, the judge should have departed from the earlier findings, or should have, or the fairness required a departure from the earlier findings because the wife was a different party. If the Secretary of State had made that point, that would have been a bad point on the case law that I've shown you. So that is the only point that the Secretary of State made. And you then get the decision of the upper tribunal, which is at page 39. Starts from page 39, and the underlying reasoning is at page 51. So if you look at paragraph 17 first, this is where the judge's reasoning starts. The first point made by the judge is that, well, the Secretary of State had no right of appeal from the first judge's decision. That simply is irrelevant. Devaslin applies whether or not there is a right of appeal.
Well, it might be relevant.
Sorry?
If you had a right of appeal and didn't exercise it, that would be relevant.
If you had a right of appeal and you
Didn't exercise it, that would be relevant. So wouldn't it be relevant that you didn't have a right of appeal in the overarching fairness analysis?
But the reason why it makes absolutely no difference is because the Secretary of State is not saying, has never said, that there was anything wrong with Judge Hodgkinson's decision. So there was no right of appeal, but assume that there had been a right of appeal. On what grounds the Secretary of State would have appealed? Moylan friend is not saying that Judge Hodgkinson made the wrong decision. So there wasn't a right of appeal, but there wasn't any conceivable basis to bring an appeal. The Secretary of State had not produced the evidence. The judge hears the evidence, the oral evidence from the wife, concludes that she's innocent. There's simply no basis on which the Secretary of State could have appealed. So the fact that there was no right of appeal against that decision is irrelevant in the circumstances where the Secretary of State is not saying that there is anything wrong with the first judge's decision. Nothing like that was said in the pleaded grounds that I've shown you. If you then look at paragraph 19, this is Judge Henson saying that, well, Judge Hodgkinson apparently did not give consideration to the developing jurisprudence in relation to ETS cases. That in my respective submission, is simply not the case. Judge Hodgkinson refers to the relevant case law, concludes that the burden of proof is on the Secretary of State, and it's impossible to see how it can be said that there was any inconsistency with the developing jurisprudence, not a point that the Secretary of State pleaded in the grounds. And you will then see a reference to certain cases without any explanation as to how Judge Hodgkinson's decision is inconsistent with those cases. It was entirely consistent with the case law. So paragraphs, and then if you look at paragraph 23, this is what the judge says, well, Mrs. Patel was not party to the appeal before Judge Hodgkinson. Yes, of course, but that makes little difference because Devaslin would apply as this court has said in a compu. The Secretary of State did not say in the pleaded grounds that, well, it was a reason why the second judge should depart from the earlier findings. There is then a discussion about the case law on estoppel and Devaslin from paragraphs 24 to 27. This has all now been taken over by what my lord said in Sultana. And the conclusion is at paragraph 27. And that, in my respectful submission, is a misdirection in law. If you look at the last sentence of paragraph 27, the judge said, well, there is now new evidence, and that evidence contradicts the appellant's claim, and that is a good reason from departing from that decision. Now, that is not the test. The test is not whether there is a good reason to depart from the decision. The test is whether there is very good reason for not adducing the evidence in the earlier appeal. This is what Mubu says, this is what BK Afghanistan says, this is what Lord Justice William Davis has said in Sultana. So the judge got the test wrong there, and if one assumes that this test is correct, then we are in an endless cycle. I mean, let's assume that this case goes back to the first year tribunal. Mrs. Patel gives evidence, she wins. The Secretary of State then comes up with some new evidence. And then we start the proceedings all over again. This cycle would never end if the Secretary of State is able to relitigate the issue simply because there is now new evidence. And then paragraph 28, the judge says that Judge Cockrell, there wasn't any proper application of principle of fairness. Well, that wasn't a point that was made to Judge Cockrell. The Secretary of State did not say that fairness required departure from the earlier decision. How can Judge Cockrell be said to have erred in law in relation to a point that wasn't made by the Secretary of State? And secondly, if there is any unfairness, in my submission, it is to Mrs. Patel. I mean, she has now spent 6 years in this litigation. She has already been through a fact-finding hearing, has given oral evidence, tendered herself for cross-examination, succeeded on the facts, and yet she is now on the upper tribunal's decision, required to go through a fact-finding hearing again. So if there is any unfairness, it is, in my respectful submission, it is to Mrs. Patel, the appellant. Now, at paragraphs 29 to 32, the judge refers to the additional evidence that the Secretary of State has provided you. That you have that evidence in the supplementary bundle. But as I sought to demonstrate, Mr. Nath, counsel for the Secretary of State, only relied on the report of Professor French, not on any of that evidence. But the judge here, in my submission, misses the real point, which is that what reason is there for not adducing this evidence at the first hearing? There isn't a good reason. It cannot be said that Laird and Marshall test is met, whether it's a classic Laird and Marshall test or whether it's Devaslin of very good reasons. And in my respectful submission, therefore, the first decision, the second decision, the decision by Judge Cockrell was plainly correct. And finally, you have at paragraph 33, again a reference to lack of unfairness in Judge Cockrell's decision. And I repeat the point that I've made. No such point was made before Judge Cockrell. How is it unfair to the Secretary of State, I respectfully invite you to consider, when she had good 4 years to get her case to the tribunal, she failed to do so. She elected, using the word used by Judge Hodgkinson, to cross-examine, to challenge the appellant's evidence in cross-examination. how is it unfair to the Secretary of State? I respectfully invite you to consider. So for these reasons, I submit that Judge Henson was not justified in concluding, in setting aside Judge Cockrell's decision on the basis that it was wrong in law. So very quickly, if I may now address the court on the points that my learned friend has made in his skeleton. If I may ask the court to respectfully look at my learned friend's skeleton, you will see that he made 4 particular points at paragraphs 32 to 35. If you look at paragraph 32, the first point my learned friend makes is that Judge Cockrell got the test wrong because Judge Cockrell focused on whether there was a good reason for not reducing the relevant evidence before the judge. My learned friend says that the question was whether there was a good reason to depart from the earlier decision. That submission is no longer sustainable in the light of what my Lord Justice William Davis said in Sultana. The question is not whether there is a good reason to depart from the earlier decision, but whether there is a very good reason as to why the relevant evidence was not reduced earlier. So Judge Cockrell correctly identified the question and decided it without error of law. The second point made by my learned friend is at paragraph 33. My learned friend says that, well, the judge made no attempt to assess and weigh the evidence. Firstly, he wasn't asked by Mr. Nath to look at anything apart from Professor French's report. And this point rather misses the point that Judge Cockrell was seeking to make. That, well, the first judge has already assessed and weighed the evidence. In absence of a good reason, taking the first judge's decision as a starting point, that those findings should be adopted. So that point does not answer the submissions that I respectfully advance. The third point is at paragraph 34. In my respectful submission, it's not a point that is well founded. So the complaint is that, well, Judge Cockrell's attention was not drawn to Jebba, Okumpu, and A. Somalia. Well, when I took the court to that decision, I demonstrated that I took the judge to Mubu and BK Afghanistan. In those authorities, the court had already considered Dejbur, Okumpu, and A. Somalia. And the decision taken by the judge is entirely consistent with BK Afghanistan and Mubu. So the fact that Jebba, Okumpu, and A. Somalia were not placed before the judge in my submission is simply irrelevant. And then finally, the fourth and final point is that Judge Cockrell gave no clear reason for adopting the earlier decision. And my learned friend seeks to read Judge Cockrell's decision to the effect that he took Judge Hodgkinson's finding as binding. This is the second last line. And when I showed Judge Cockrell's decision, I demonstrated that he said expressly that the first decision was no more than a starting point. Well, he did not proceed on the basis that that decision was binding. He identified the starting point, then considered whether there was an explanation. There wasn't any explanation as to why the evidence was not reduced. And considering the submissions that were made, promulgated a decision that was entirely open to him. So for these reasons, I respectfully submit that these points do not answer the appellant's appeal, and I therefore invite you to restore Judge Cockrell's decision. So unless I can assist you any further, these are my submissions.
Could I just ask one point, which actually doesn't arise out of your submissions? All of this happened because Mr. and Mrs. Patel were served with an IS 151A form.
Yes.
Did they have any right of appeal against the issue of that form in itself?
So that is the issue that was addressed in Assam. So there was a right of appeal, but that right was exercisable only from abroad.
Right.
So what the Secretary of State did in 2014 after the Panorama documentary was to issue 48,000 removal decisions without giving the appellants an effective remedy in the form of an in-country appeal. And the courts then concluded that judicial review was not available because there was an alternative remedy in the form of a fact-finding appeal. In Assam, the court concluded that an out-of-country appeal wasn't an effective remedy, because you cannot remove a person and then to expect him to appeal from abroad and to challenge the finding. And then in Austin, the court contemplated that in those circumstances, as it happened in this case, the appellants would put in some human rights submissions. The in-country right of appeal arises against refusal of a human rights claim. And that's what happened in this case. When they made the human rights claim, those claims resulted in an in-country appealable decision.
Right, so in April 2015, when these notices were issued, you wouldn't sensibly have expected Mr. or Mrs. Patel to have mounted an appeal because
there wasn't an in-country right of appeal.
And Arson hadn't explained what the position was by that time.
Absolutely, and that's why they spent good 4 years in making applications and judicial review claims. You must have seen a reference to a settled judicial review claim in the papers.
Yeah.
So that was settled. I haven't seen the papers, but I assume that was settled pursuant to the guidance given in Austin. There were settlements of thousands of judicial review claims, and I suspect that's what had happened in this.
Right. Because Judge Hodgkinson, in his decision at paragraph 34, noted that there was no attempt by Mr. Patel or his wife to seek to appeal the notices, which seems to be contrary to what you say would have been the position.
Yes, so in order to appeal,
have to go out of country.
Absolutely, to return to the country and then to bring an appeal.
So
in that sense, of course, there was no attempt to appeal, because an attempt would have required them to leave the country.
Because he went on to say, it would appear to be erroneously, that the forms did grant in-country rights of appeal.
That's wrong.
Yeah.
As I submitted, the judge, after the finding that Mrs. Patel, the Secretary of State, hadn't proved the allegation, the judge should have allowed the articulate appeal, but the appeal failed.
Yes, all right. Thank you.
Anything else?
No, thank you.
Thank you very much, Mr. Malik.
Very good.
Yes, Mr. Chapman.
And I take off the mask.
Yes, of course.
My lady, my lords, I start a very simple course of mission, which is that Upper Tribunal Judge Hanson's judgment, his determination, was spot on. The central legal principles, which I say were apt to guide him and all the other judges that have heard this appeal and this court, are as follows. First, that in immigration cases there is no place for res judicata or issue estoppel. Instead, the guidelines in Refusal are thought to be applied, the juridical basis for which is essentially fairness. In cases involving not the same parties, but different parties with a material overlap.
This is number 2, is it? This is number 2, is it?
This is number 2.
Yes. So
I'll
different
give you the
parties,
numbering.
but a material overlap.
Refusal applies, but with, and I emphasise this, with appropriate modification. Point that my Lord Justice Moylan has made. And relatedly, what fairness requires will depend on the factual circumstances as they arise. I think that's number 3. Number 4, whatever the position in same party cases, Ladd and Marshall principles or something approximating to them do not apply in material overlap cases. fifth, in material overlap cases, earlier findings are the starting point, an important starting point. But the second adjudicator or judge cannot avoid the fundamental obligation to address the merits of the appeal he is determining and to make findings of fact conscientiously on the evidence available. Sixth, in material overlap cases, second adjudicators should generally look for a good reason or a very good reason to depart from earlier findings. Which may or may not be connected with the reasons why relevant evidence upon which reliance is now placed was not previously adduced. But in such cases, a very good reason may simply be that the evidence now sought to be adduced is sufficiently compelling to justify a different finding. It all depends on what fairness requires in the circumstances. Seventh, the Refusal guidelines are imbued with flexibility, with the fundamental aim being to achieve justice. I'm obviously going to seek to develop those. A number of them are not in any sort of dispute. I'm going to focus on the idea that there is a general confluence in all of these cases, whether or not same party or material overlap cases, and I suggest that there is an important distinction to be drawn as between the two in the application of the Refusal principles as modified. I'm going to address the suggestion that there is confluence in specifically material overlap cases as between Refusal and Ladd and Marshall. And my basic submission is that in these sorts of cases, Ladd and Marshall, or something like it, does not apply. And that the key for any tribunal or court considering the issue is to treat earlier findings as a starting point and consider whether the justice of the case requires the earlier findings to be adopted, or alternatively whether there is some proper basis, proper judicial basis to come to a different finding of fact. The foundation stone is Jebbar. I'm going to attempt to avoid taking you to any of the authorities, but I'll give you references. The foundation stone is Jebbar, which is at tab 7. And I say that's the foundation stone because that's the first Court of Appeal case in which the Court of Appeal approved the Devasseelan guidelines. It was a same party case, so I don't get onto the material overlap distinction yet. But I make the following general observations. Well, first, that they approved the Devasseelan guidelines. Secondly, that they rejected at paragraphs 27 to 28 for the purposes of your note, Rabinder Singh QC's submissions that Devasseelan's founded on res judicata and issue estoppel principles. Court finding that they're excluded from the statutory jurisdiction of the IAT, as it was. And observing at paragraph 30, again for your note, that the adjudicator's fundamental obligation remains to decide each case on its merits, an obligation which is preserved by virtue of the flexibility built into the guidance. That's paragraph 30, a similar but perhaps more powerfully expressed way of putting the same point is at paragraph 40, which is really, in many ways, the crescendo of the judgment, in Jabbar. So that I submit as the foundation stone. I then turn to the material overlap cases, which originate really with Ocampo. Tab. Oh, I've made a rick in my
Tab 8.
Tab 8. Thank you. With Lord Justice Auld giving the lead judgment, I should have said that that Jabbar is
Judge.
is Lord Justice Judge. Coincidentally, I bumped into on my way to court this morning.
Did you tell him you were going to cite it?
I did, yes. He told me he suspected he was almost certain to be overturned. I didn't tell him which judgment. He was joking for the avoidance of doubt. So Ocampo, paragraph 25 is the starting point, where Lord Justice Auld explains that the Devasseelan guidelines apply in cases like the present where parties aren't the same but there's a material overlap. Clearly the guidance may need adaptation according to the nature of the proceeding, its materiality to securing a just outcome in the second appeal, along with consistency in the maintenance of firm immigration control. Should also be borne in mind that admission of new evidence may, as a matter of fairness, operate for as well as against a claimant for asylum, as always in those circumstances. In immigration matters, as in other areas of public law affecting individuals, public policy interests of firmness, consistency and due process may have to be tempered with considerations of fairness in particular circumstances. Paragraph 26, the first sentence deals directly with the suggestion that Ladden-Marshall principles arise in this context or fall to be applied, and rejects that suggestion. And similarly, to the same effect, the final sentence of paragraph 26. And the same point, first sentence of paragraph 28. And the same point in paragraph 29 in the sentence starting, it also follows in my view that the AIT did not. And all the way to the end of that paragraph. Paragraph 27, the first sentence is also worth referring to at this point, which is to the slightly different point that this is about fairness, maintenance of proper immigration control and application along the lines of Devasseelan. which are, the point is made in the final sentence of the final two sentences of paragraph 29, imbued with flexibility. I turn next to AA Somalia. I don't ask you to turn to this one because I'm going to be very brief in summarising it. It's at tab 5. Suffice to say that for these purposes, that the Court of Appeal, or at least the majority of the Court of Appeal, Justice Conworth and Ward with Lord Justice Hooper dissenting, followed Ocampo with minor qualifications concerning specifically some of the differences in the application of Devasilan in other party cases, in material overlap cases. I then turn to AL Albania again. These are all material overlap cases. AL Albania is at tab 9, and it's important in my submission.
You want us to turn that one up?
Please.
Thank you.
Lady Justice Nicola Davis gave the lead judgment in that case.
Yes.
And in my submission, it's worthy of a detailed read because it conveniently encapsulates the applicable principles in material overlap cases. At paragraph 20, this aspect of the appellant's case is summarised. Basically an argument, again, that a test approximating to Ladd and Marshall should be applied in this context. And then at paragraph 22, paragraph 21, going into paragraph 22, the Lady Justice Nicola Davis addresses and rejects that argument in terms. Paragraph 22, the appellant's contention that some form of issue estoppel or Ladd and Marshall test should apply to constitutional authority, referring to Jebbar and Ocampo.
Sorry, that's setting out what the respondent said in that case, isn't it? Paragraphs 21 and 22.
Oh, that might
And then
that might be right.
and then there's
Yes.
discussion from
That might
paragraph.
be. Forgive me. You're absolutely right, my lord. Although fair to say that during the discussion at 23 to 25,
Yeah.
Lady Justice Nicola Davis gets to the same place.
Well, I don't know who's put the bold line down the side, but the opening passage of paragraph 25 is
Yes.
the kernel of what she has to say, isn't it?
Yep.
Yeah. And I'll, paragraphs 21 to 25 as a whole,
23 to 25.
23 to 25 are the key.
Yep.
21 and 22 express the Secretary of State's case, which is, well, it's a matter for you, I'd suggest, effectively accepted in the discussion. The kernel, as my lord puts it, is indeed to be found here, that the earlier determination is the starting point, and it should be followed unless there's a very good reason not to follow it. But in this case, Lady Justice Nicola Davis, giving the lead judgment with whom their other lordships agreed, concluded that cogent evidence undermining the earlier finding can amount, as a matter of principle, to a very good reason, regardless of whether or not that evidence could and should have been placed before the first adjudicator. And in that case, like this, the cogent evidence which gave rise to the very good reason for the departure had been available for years, or at least a year. Yeah, over a year.
As I understand it, you correct me if I'm wrong, the chronology in AL Albania, first decision was in 2013. Subsequently, the material was obtained that demonstrated that whoever it was had been coming and going in a way wholly inconsistent with fear of persecution. That was in 2015. The material became available. I'm looking at paragraph 9 of the judgment. This is a letter dated 28th of July 2015. And then that was what went before the second first-tier tribunal hearing, which unsurprisingly led them to conclude that the appellant in that case was not being truthful.
Yes, I don't. I'm sorry. I don't have a note of the chronology, and that sounds like it's probably right.
I mean, I don't have a note of the chronology. I'm simply reading the judgment.
Yes. Well, I can do the same if you.
Yeah.
Like,
Well, no.
I'm sure that
I think
the Lordship has it.
the point that would be made against you is, well, on the facts of this case, there was a perfectly obvious reason why the second tribunal made a different decision, because they had evidence which the first tribunal didn't.
Yes.
And on the face of it, the first tribunal couldn't have had, though that particular issue wasn't investigated.
Yes.
And what's being said here is the first tribunal could have had the evidence.
I do get your Lordship's point.
Yeah.
It may be that I've got the chronology wrong in relation to AL Albania. I'm pretty sure I don't have the chronology wrong in relation to, I think it's Ocampo. So let's go back to, I don't ask you to turn it
back to it.
No, the facts according to my note, I'm sure Mr. Malik will pipe up if I'm getting it wrong, is that the material which the Secretary of State in Ocampo was committed to abuse in the second appeal had been in her possession for 3 years before the first appeal, with no suggestion that there was any good reason for her failure to adduce it then. And that wasn't a barrier to the tribunal or adjudicator coming to a different finding, because the test isn't the Ladd-Marshall test in the material overlap context. So the question was not, for the purposes of Ocampo, whether there was a very good reason why the material hadn't been adduced, albeit I accept, of course, that that is a relevant and possibly highly relevant factor in the consideration of what fairness requires. But the core question is whether or not there is a sufficiently good reason, a very good reason, judicially adequate reason, why the tribunal should depart from the earlier findings. And forgive me if I have got the chronology wrong in AL, and if I'd be permitted to, I might go back and just check that and send a note to the court one way or the other.
I think we can see
I
for
don't
us.
want to
Well,
take a bad point.
we can see for ourselves. And anyway,
Yeah.
you say Ocampo demonstrates that the chronology is only one part of the picture.
Yes.
So where do we go from
We go
AL
from here
Albania?
to Mubu, but again, I don't ask you to turn Mubu up. I don't think that's at tab 6 for the note. I don't. address it in detail, but I would refer for the note to paragraph 50 and then paragraphs 51 and 52. 50 records the Secretary of State's submissions in Devasseelan, and paragraphs 51 to 52 cite and endorse CMG Ockleton's findings in AA. Actually, I might just briefly turn to paragraphs 51 and 52, tab 6.
At 51, if there's no good reason for departing from it, it must, as between the parties of that litigation, be treated as settling the issues with which it was concerned and the facts on which the determination was based.
And Mubu, I recognise, is a tribunal authority, but in broad terms approved by the Court of Appeal in BK, Afghanistan. So what I submit is that it's clear from this consistent line of authorities which deal with the material overlap position that there is no confluence between Devasseelan, or at least it's the application of Devasseelan in that context, and Ladden Marshall. There need, nevertheless, to be good reasons, or very good reasons, to depart, and powerful evidence that the first determination was or may have been wrong may amount to a sufficiently good reason, sufficiently good basis to depart from it, apart from the earlier finding. And those authorities fall to be considered in line with what is said in Jebar and BK Afghanistan about flexibility within Devasseelan and about the juridical basis for the Devasseelan principles being fairness, and about the continuing fundamental obligation to address the merits of the appeal as it rises, conscientiously making findings of fact which the second adjudicator believes to be correct. Can I say this also, that it is easy to understand in my submission why there might be a difference in the principles or in the application of those principles as between material overlap cases on the one hand and same party cases on the other. It probably does come down in my submission to the application of those principles, albeit recognising that respect and emphasis needs to be placed on the appropriate adaptation point made in Ocampo itself. Probably skin the cat in the same way, whichever route one takes, whether it's slight variation of the principles or difference in the application. But it's easy to see why, in one case where the Secretary of State seeks to subvert an earlier judicial finding in favour of a particular applicant by administrative action, fairness may demand one thing, whereas in circumstances where a different appellant is concerned, involving a material overlap of evidence, different considerations may apply. In other words, fairness may demand something else. and that would explain and navigate a way through the various authorities relating to material overlap on the one hand, and those cases which Sultana is an example on the other. The two are eminently reconcilable in my submission. In any event, for the reasons I've gone through at some length now, it's authoritatively clear that whatever the position in same party cases, there is no confluence between Devasseelan and Ladden Marshall principles in material overlap cases, and that's all that matters for the purposes of this appeal. Can I deal briefly, please, with application of those principles in the context of this appeal? The essential problem with the appellant's case in my submission is that First-Tier Tribunal Judge Cockrell, on the second determination, didn't look beyond the question of whether there was a very good reason for the failure to adduce the evidence of deception. And whilst he may have said I treat it as a starting point, he in effect treated it as dispositive. The evidence upon which the Secretary of State was at the appellant's appeal rather than the husband's appeal seeking to rely was, as Upper Tribunal Judge Hanson found at paragraph 31, I didn't ask you to turn there, but it's at page 53, part of his judgment, incidentally, that isn't and couldn't sensibly be challenged. That evidence clearly contradicted the core of the appellant's claim, it's paragraph 31, and clearly discharged the initial evidential burden on the Secretary of State. I mean, I would submit that it's undoubtedly very powerful evidence of deception, which plainly changed the complexion of the evidence. There is, I freely accept, in fact it's a positive part of my case, absolutely no good evidence, absolutely no good reason why that evidence shouldn't have been adduced in the husband's appeal before First-Tier Tribunal Judge Hodgkinson. The reason recorded at paragraph 30 of Judge Hodgkinson's determination, page 108, is basically coherent.
Sorry, it's basically
Incoherent. The reason given by the Secretary of State.
Oh, I see. Yes, I
why...
thought you meant Judge Hodgkinson was incoherent.
No. Judge Hodgkinson was entirely coherent on this point.
Yes. So, sorry to interrupt. Judge Hanson was, to be blunt, rather unfair to Judge Hodgkinson when he said that Judge Hodgkinson claimed the Secretary of State didn't provide any reasons. A reason was given, when in fact what Judge Hodgkinson said was there was no good reason, and you accept there wasn't any good reason.
There wasn't a good reason.
Right, so that part of Judge Hanson's conclusion you can't support.
I can't. No, I don't think I can.
Can I just be clear though, when we're talking about a good reason, we're focusing at the moment on no good reason for failing to reduce the evidence at stage one. But from my brief reading of the judgment of Lady Justice Nicola Davis in AL Albania, at paragraph 25 that you took us to, the good reason for departing doesn't necessarily have to be, or is not exclusively referable to the reason why the evidence was not produced at first time round.
Precisely, my lady. And that really is my fundamental submission.
And so you would say that this is notwithstanding, your submission, I think, is that notwithstanding the fact that the Secretary of State can't offer any acceptable good reason why they simply failed to produce the evidence that they've had for ages.
Yeah.
On the other hand, you would say that the good reason is seen by the quality of that evidence and fairness demands,
Yes.
in the same way as Nicola Davis LJ said that it's a good reason for departing from the determination as it contradicted a core aspect of the appellant's claim.
Precisely.
That's the other side of the good reason coin, you would say.
So exactly. So my submission is that the fundamental question is whether there is a good reason for, very good reason for departing.
From the determination.
Yes, from the determination. And
Because,
one
because you would say, sorry to interrupt you, but because just following that through, you would say that if you attach it exclusively to why the evidence wasn't available, you're falling into the trap of saying it's a Loudon Marshall case, which we know it should not be.
Yes.
Thank you.
Yes.
Sorry, I've put you out of your track.
You have slightly, and I'm going
Sorry
to.
about that.
I'm going to quickly
Regroup.
I'm going to quickly regroup. Yes. So I accept that certainly there was no good reason for the failure to adduce the material, but that's not the end point. And there is the question which Judge Cockrell should have addressed, but didn't address, is not merely whether there was a good reason for failing to adduce it, but should have assessed the quality of the evidence that was being sought to be adduced. And applying the relevant authorities, which I've taken you through, determined whether, having regard to all of the relevant factors, one of which was no doubt the absence of a good reason for failing to adduce it previously, whether Devasseelan, with appropriate modifications, and getting to the nub of it, whether justice required fairness, required the previous finding to be followed, or whether there was a proper basis to depart from the previous finding, having regard throughout all of this to the fundamental obligation which rested with Judge Cockrell to make conscientious findings of fact on the available evidence, addressing the merits of the appeal before him. He simply didn't do that. There's no suggestion that he did that. Mr. Malik now makes the point, well, Judge Cockrell no doubt had regard to the right principles because the relevant authorities were referred to in the authorities that Judge Cockrell had been referred to. In other words, he should have looked at the authorities that he'd been referred to and seen the authorities that were cited there and gone and looked at them, and from that it can be taken that Judge Cockrell had regard to the right legal authorities. So, for example, AA Somalia, Jebar, AL Albania, to which no reference is made in the judgment. That's not a good argument. There's simply nothing within the judgment of Judge Cockrell which suggests that he truly had regard to the operative legal principles. There's also no suggestion that Judge Cockrell recognised that the Devasseelan guidelines are imbued with flexibility enough to be applied flexibly depending on the justice of the fairness of the case. and that's a point that Judge Hanson makes. In sum, there's no sign that Judge Cockrell understood the nuances to the legal test to be applied, specifically in material overlap cases, and every sign that he didn't. He was fundamentally wrong to treat the question of whether there was a very good reason for the failure to adduce the evidence of deception as the only relevant question, the only relevant factor. Relatedly, in my submission, the decision to determine the appeal before him on the basis of submissions only, rather than looking at and weighing the evidence, undertaking a sort of multifactorial assessment with the absence of a good reason for failing to adduce the material before on one side and the cogency of the material on the other. That decision to determine the appeal on submissions only breaches, in my submission, the fundamental and binding duty to have regard to the true merits of the appeal and make conscientious findings of fact on it. And finally, Judge Cockrell failed to give adequate or comprehensible reasons for his finding that, and I quote, "nothing has really been adduced before me which would enable a different conclusion to be reached properly." The reasons for that conclusion simply aren't articulated in any clear sense. The inference being that the judge based this conclusion exclusively on the absence of very good reasons for failing to have adduced it previously. If that was the reason, then for the reasons I've expressed, it's a bad reason, it's an error of law. If that wasn't the reason, then there's a reasons error in this, in the judgment, a failure to set out legally adequate reasons for the determination. And so for those reasons, in my submission, Tribunal Judge Hanson was absolutely right to allow the appeal. Can I just, I'm conscious that I've made on a number of occasions the point that it's authoritatively clear that a fundamental obligation is to determine appeals on their merits and having regard to the duty to make conscientious findings. Can I just please, I'm conscious I haven't directed you to authority for that proposition. Could I just briefly in my note find that?
Certainly.
I think the answer to this is at paragraph 43 of BK Afghanistan at tab 2. I'm certain that it's in my skeleton argument anyway. I'm sorry, I seem to have mislaid my note. Paragraph 43 of BK Afghanistan is So paragraph 43 of BK Afghanistan, starting at Mr. Malik, did not go so far as to say Mr. Malik did not go so far as to say that a tribunal in such circumstances should refuse even to consider whether material put forward by an appellant could cast doubt on the correctness of earlier factual findings. He accepted that as a matter of practice, the tribunal must address its mind to the reasons put forward by the party which is seeking to depart from the previous finding as to why that finding is unreliable, so that it should, and I think there's a missing not there, in effect be carried forward into the determination of the appeal now before it.
Thank you.
That's obviously the...
Well, it's the middle of paragraph 44.
Yes, exactly.
Yes.
Yeah. So 43 is to the slightly, to emphasise the point that I've already made, that it's
Yeah.
not merely about good reasons for the failure previously to adduce it, but rather...
Well, in the middle of
a wide
44,
question.
we have the wording that you've adopted in your submission.
Precisely.
Conscientiously decide the case in front of them.
It-
Spotted by my lord.
Exactly. And that harks back to paragraph 40 of Jebar, which is the other reference that I had hoped to bring you to and belatedly now have.
Yeah.
So, my lady, my lords, unless there's anything I can help with, those are my submissions.
Only this. The case for the Secretary of State in relation to this appellant was you've engaged in a deception. You behaved fraudulently.
Yep.
Is it of any relevance to this overarching fairness point that a tribunal, if presented with evidence that a previous tribunal hasn't been, for whatever reason,
Yes.
evidence of fraud, is that of significance?
Well, I would certainly suggest that it is or is capable of being a relevant factor in the overall balance. It probably really depends on judicial discretion. But I would certainly suggest that the circumstances of what is being alleged, the issues to be determined on the appeal are likely to be, or at least may in principle be, relevant factors in the fairness assessment. And I note also in passing in this respect the final paragraphs in Sultana where your lordship makes the point about the application of Land Marshall principles in the context of fraud. For the reasons that I've addressed the court in my submission, we don't need to go to Land Marshall, but what one might extrapolate from that the consequences of allegations of fraud in the Land and Marshall context, that similar considerations apply in the Dever-Seaman context.
Yes, thank you.
Thank you very much. Anything in reply, Mr. Malik?
The issue of law between the parties appears to be whether the Secretary of State is required to put forward very good reasons for not adducing the relevant evidence at the first hearing. Moylan and Friends says that Laird and Marshall test or principle 7 of devassing does not apply to cases of this nature, the material overlap cases. So that is the issue of law, I think, between the parties. I take no issue with principles 1, 2, 3, and 7 as Moylan and Friend identified at the outset. And in support of his proposition, Moylan and Friend took you to two authorities, Ocampo and A.I. Albania. And Moylan and Friend submitted in answer to a question by my lord that, well, the chronology makes no difference. But that submission is not one that, in my respect, submission can be accepted. May I take you to tab 8 first, a component, and to assist the court as to why chronology is relevant. Now, a compo, as the court knows, was a case where the daughter's appeal was allowed. There was then an appeal by the father, and at the father's appeal, the Secretary of State sought to adduce interview notes from 1997. Those notes were not adduced in the daughter's appeal. May I take you respectfully to paragraph 8 of the judgment just to show you what had happened in that case. So the interview notes were relevant to the father, and see the last sentence. The Secretary of State argued, unlike this case, that new evidence could not have been placed before the first judge, could not have been produced. I'll explain the reasons for that. So although the interview notes were in existence, the Secretary of State could not have provided those notes to the first judge. And the reason for that was this. See paragraph 13. There is a finding by the tribunal, middle of the quotation. It would have been most inappropriate for the Secretary of State to have adduced the appellant's interview records in the daughter's appeal, because those records were confidential. So it wasn't possible for the Secretary of State to adduce the evidence that was adduced in the second appeal in the first appeal. So that is what had happened in this case. And if you then go to paragraphs 21 to 23, Moylan asks you to, would invite you to consider those paragraphs. These are the submissions that were made by the Secretary of State. And if you look at paragraph 23, so the Secretary of State submitted that this was new and compelling evidence, new in the sense that she could not have produced it earlier. There was a good reason for not being able to produce the evidence earlier. So this is the context in which you will consider paragraphs 25 and 29. So paragraph 29, de Varcelin applies.
Don't we have to look at 28 as well?
I mean, what Lord Justice Old said was, actually, the confidentiality point was misconceived.
Yeah.
And in paragraph 29, he said the tribunal didn't need to go as far as they did. They had sufficient flexibility in applying de Varcelin to take the decision it did, regardless of that consideration.
But the reason for that is set out in the first part of paragraph 29. Now you'll see that immediately after the sentence that, Lord, you have picked, it was said that reliance by the Secretary of State on the new evidence is not a collateral attack on the refugee status or otherwise an abusive process. But here, the new evidence is indeed a direct attack on the entitlement of the appellant, the finding that was made in relation to the appellant. True it is that there is ample flexibility, but there is, in my respective submission, hardly any doubt that de Varcelin guidelines, including guideline 7, would apply to cases of this nature. The argument was put scarcely, this is paragraph 28, in terms of Ladd and Marshall test, and as my Lord rightly pointed out, it was then said that there is sufficient flexibility within de Varcelin, and we know from what my Lord said in Sultana that principle 7 of de Varcelin essentially mirrors Ladd and Marshall. In my submission, this is not an authority for the proposition that if there is that the Secretary of State is not required to provide a reason for the failure to adduce relevant evidence in material overlap cases. The second authority to which Moylan and friend took you to is AL Albania. You have that behind tab 9 of the bundle. There was a favorable decision in 2011, but in 2013, and then see paragraph 19 in 2015, 3 years after that decision, the Secretary of State obtains new evidence and seeks to rely on that evidence in the second appeal. The second judge looks at that evidence, departs from the earlier findings, and that is the context in which Milady and Lord will consider what is said at paragraph 25.
I'm sorry to interrupt, but did you mean paragraph 19?
Sorry, I'm so sorry. It's my fault. It's paragraph 9, in fact.
That sounds more like it. Thank you.
So paragraph 9. This is.
Yes, I've got it. Thank you.
So well after the first decision, and on 28th of July 2015, new evidence was obtained. And then you consider paragraph 25, the paragraphs 24 and 25. So if you look at paragraph 24 first, you'll see that the judge whose decision was upheld took Devasaline as a starting point, as it had happened here. But the appellant sought to argue that the very first determination should have been something stronger than a starting point. Court took the view that that was contrary to the pleaded grounds of appeal. But then see paragraph 25. So true it is that it is said that the evidence did constitute a very good reason from departing from the earlier decision. But that is in the context of a case where the new evidence came into existence after the first decision. The point of distinction here is that the evidence that the Secretary of State seeks to rely on was available, but was not adduced.
Thank you.
Assuming that the court resolves this point against me and takes the view that the Secretary of State is not obliged to give a good reason for not adducing the relevant evidence, and the question is whether there is a good reason to depart from the earlier decision as Miller and Friends submitted. I mean, surely that good reason had to be provided to the judge who is deciding the case. If no good reason is provided to the judge, how can that judge be said to have erred in law? And that with respect is the point that Lord Justice William Davis was seeking to make in Sultana towards the end of the judgment at paragraph 52. My Lord said about the decision taken by the tribunal in that case, his decision cannot now be criticized within this appeal for failing to deal with an issue not raised by the appellant. The same applies to the respondent. So Miller and Friends says that, well, the evidence that the Secretary of State has now produced is quite compelling. And that is the good reason to depart from the earlier decision. What I invite the court to consider is whether that point was ever made to the judge. May I just, to respond to what Miller and Friends said, take the court to page 61 of the bundle. This is the decision by Judge Cockrell. Now you have the record of submissions made on behalf of the appellant at paragraph 18 to 24, and then see submissions made at paragraph 25. No good reason for departing from the earlier decision was provided to the judge. 2 points were made. Firstly, that the first judge did not allow the appeal, and secondly, have regard to the French report. The points that my learned friend is making before this court were not made to the first year tribunal. They were not, in my respectful submission, part of the pleaded case of the Secretary of State to the upper tribunal. And that is the context in which Milady and Lord will consider the reasons challenge. Well, if no good reason is provided to the judge, what else the judge is expected to say other than what he said at paragraphs 27 to 34? Now, my learned friend says that the last sentence of paragraph 30 is not adequately reasoned. This is where the judge said that, well, nothing has been added before me which would have enabled a different conclusion to be reached properly. But that conclusion cannot be criticized in the circumstances where the only submission that was made to the judge is one that is set out at paragraph 25. Now, my learned friend says that the judge did not take the first decision as a starting point. He took that decision as determinative and allowed the appeal simply on the basis that there wasn't a good reason to depart from the earlier decision. The answer to that point is that the judge expressly says that he was taking the first decision as a starting point. And Learned says that, well, the judge simply focused on there being no good reason for not reducing the relevant evidence earlier. The answer to that point is that if you look at paragraph 32, the judge has already made the findings. Here, he is adding for avoidance of doubt that the Secretary of State had provided no explanation as to why the report was not made available earlier. But he had given ample reasoning at paragraphs 27 to 31. This includes paragraph 29. The only point, I emphasize again, the only point that was made by the Secretary of State was that the judge should look at Professor French's report. Well, if that is the only point, then in my submission, the judge was entitled to say that the first decision remains good and there is no proper basis to depart from it. The final point that Lenfren makes is that the judge did not appreciate the principle of fairness and flexibility that is inbuilt within the Vaseline. Well, where is it, I respectfully ask the court to consider, the judge was ever asked by the Secretary of State to apply the flexibility? The Secretary of State did not submit to the judge that the principle of fairness required a departure from the earlier decision. And you have my submissions as to fairness in any event, that if there is any unfairness, it is to the appellant. And finally, my Lord Justice William Davis made an observation at the end as to whether the fact that there is an allegation of deception is relevant. In my respectful submission, there isn't a special rule for cases involving deception. I mean, serious as it may sound, there are equally serious matters that were subject of discussion in the authorities that you have seen. A person makes a protection claim, says that his life is at risk in the country of origin. That is far more serious on one view than an allegation of deception. Courts have consistently made it clear that the Vaseline would apply to those cases with equal cogency. And as the court knows, BK Afghanistan was a deception case, so was Mughal. And for that reason, no special rule exists for cases of this nature. So unless I can just go any further, these are my submissions.
No, thank you very much. That's most helpful, Mr. Malik. Well, thank you both very much indeed for your submissions and your written material. You won't be surprised to hear that we're going to reserve our judgments, but conscious as we are that of the importance to particularly your lay client, Mr. Malik, we will endeavour to get the judgments out as quickly as we can. They'll be sent out in the normal way, in draft, for any typographical, grammatical errors, but not for further submissions or further argument. And then we'd ask you in due course to be able to agree an order as between you. Any ancillary matters we ought to be able to deal with in writing, please. So thank you very much.